At this time in history, is there another way to resolve our disputes rather than spending years in litigation and mortgaging our futures to pay exorbitant legal fees? Are we a culture that's addicted to conflict and drama, or is there another way to resolve our disputes? I'm Mary Lynn Schiavi, and welcome to Pro Se Nation. Joining us on Pro Se Nation today is Janine Dickey, an attorney and professional mediator and arbitrator in Bridgewater, New Jersey. Her practice focuses on resolving disputes related to business, insurance, property, estate, and employment. Also joining the discussion is Terri Reicher, an attorney, mediator, and arbitrator in Wayne, New Jersey, who specializes in dispute resolution in the areas of commercial transactions, employment, pharmaceutical, healthcare, real estate, banking, elder conflicts, foreclosure, and trusts and estates. Marvin Schuldiner will also join us. He is a mediator and arbitrator based in Franklin Park, New Jersey, who specializes in divorce, elder and family mediations, as well as commercial mediations and arbitrations in the areas of contracts and commercial transactions, employment, labor, and construction. Alternative dispute resolution. A lot of people may not have heard that term. It's also referred to as ADR. Before we get into defining our terms, I'd like to kind of focus on a broad philosophical question. I started to think about this when I thought about all of the programs, television programs that we've watched for the last 50 years or so, starting with Perry Mason, LA Law, Boston Legal, and now The Good Wife, which is very, very popular now. And they've all had a pretty long shelf life. In 2011, there happened to be a television show called Fairly Legal, and it was actually about an attorney turned mediator. Sadly, it only lasted 2 seasons. And now, that could have been for any number of reasons. But I started to think about the way the American public seems to be drawn to courtroom drama. So my first question is really, are we as a society addicted to drama and conflict? And if we are, how likely are we to move toward alternative dispute resolution practices?
I don't know whether addiction is the correct word, but I do agree that our nation is, let's say, predisposed to conflict, and in fact, human beings are predisposed to conflicts in some nature. Many people are predisposed to view situations or view the world in absolute terms, sort of like it's right or it's wrong, it's black or it's white, where if you look at a situation or an event with an objective perspective, most of the time, it's a shade of gray. It is not an absolute right and an absolute wrong. In my mediation practice, I mention this to people. It's a psychological, it's not a theory, it's proven. It's called fundamental attribution error. And very simply, that means if Terry says something to me, a fundamental attribution error, I would interpret that with internal factors, such as if you say, Janine, I can't talk to you. I would be thinking, she's mad at me. Oh, she's not a very nice person. Oh, she has a bias against me, something like that. And fundamental attribution error, you tend to de-emphasize the environmental or circumstantial external factors, which most likely are the case. She just spilled a cup of coffee. She can't talk to me on the phone.
Right.
Her new grandchild is about to do something dangerous. She can't talk to me on the phone. There is a slew of things. So in a mediation practice, I tend to point that out.
So you're saying we go through, it's natural to then, whatever information is coming in, we're kind of putting it through our own filter.
Yes.
And sort of what maybe we're predisposed to thinking or feeling. So if we're feeling
Yes.
badly about ourselves, whatever that other person says may fuel that feeling. Or that's sort of what I'm getting.
That is what I'm saying. And
Okay.
and there's one other thing that I think fuels the adversarial environment that we live in. And that's, you've all heard the phrase, the end justifies the means. Mm-hmm. I think that's a very dangerous thing because it will take thinking in absolutes and intentionally use it strategically. So you can have a very worthy end or a goal,
right,
or something to achieve. But if you truly believe that the end justifies the means, it's going to result in rhetoric. It's going to result in inflamed passions. It's going to result in extreme actions and possibly an escalation of a dispute which gets out of control. Mm-hmm. Mm-hmm. That's the environment and society I think we live in.
There's another environment that I think we have, and what it is, frankly, is a supply and demand. And we have a current system where we have lots of lawyers. Lawyers are taught to bring lawsuits. And so long as there are lawyers who are out there who are ready, willing, and able to bring these suits, there is a basis we see on TV, we see the commercials in terms of encouraging you to bring a suit to resolve your conflict. There's an old lawyer's joke, which basically says if you have one lawyer in town, he starves. When you get two lawyers that come to town, they both are very successful. Well, that's a function of the litigious society. You now have someone to represent the plaintiff, you have someone to represent the defendant. The other thing is, besides the TVs and the movies, there is a basic lack of knowledge, which you've identified through doing these programs, in terms of if the public were to realize that the latest statistics, for instance, are that only 1.2% of cases, for instance, that are filed in the federal court system ever go to trial. If they would have realized that bringing the suit and having a trial are two very, very different things, perhaps they would be more aware, more willing, more encouraging of the alternates to resolving the disputes that we're talking about.
Well, I think we're also, too, because of movies and television dramas, I think many people have gotten a sort of skewed sense of, that triumphant, the underdog wins in the courtroom, and that almost never happens, right, in reality.
The Perry Mason moment very rarely happens in a courtroom.
One of the questions Marvin and I had spoken with all of you prior to this interview, and I thought was very interesting. You had an interesting historical take on how we ended up in this adversarial combative mode. Can you enlighten our audience?
Sure. I mean, if you look back to some of our earliest documents, right, like the Bible, a lot of conflict in the Bible. Right. The Bible tries to give us laws and structure around which to organize our society. And if you look back to Moses leading the Israelites through the desert, there were 600,000 Israelites at one point, and he had to listen to all these disputes. His father-in-law came to visit him one time and said, who was the leader of the Midianites, and said, you might want to create some sort of structure to help you with this. And if you fast forward through history a little bit, you go to the King of England, he had the same problem. Too many disputes to listen to, and he started to appoint judges and chancellors to hear these cases. And from that, our modern court system has evolved. Unfortunately, we've also had other ways of resolving our disputes. A good example I like to give of a way that doesn't really work out very well is Alexander Hamilton and Aaron Burr. They had a long-term dispute throughout their relationship. It culminated in a duel, 20 paces, which ultimately led to the death of Alexander Hamilton. So there's had a rather permanent resolution to their dispute.
So our judicial system right now is a little better than that.
It's a little more civilized way of handling things. People might complain about it being expensive. People might complain about it taking a long time to get through the court system. But at the end of the day, it's a lot more civilized and probably less expensive than an alternative to dueling or other types of violence that we still see today. People resolving their disputes who don't go to court. Unfortunately, we see it in our cities, but that's still out there.
On our in the first Pro Se Nation show program, we did talk about one of the interviewees did raise the point that even though there are many flaws in our current system, it's probably the best thing we have right now. So, but that doesn't mean that we can't strive to improve it, right? So I think since a lot of people, this program is really about helping the average person better understand the law and legal principles. So I think before we go any further, it would be great to actually define alternative dispute resolution and the components of that and the differences. Did you want to take the lead on that, or?
I'll take the lead on that.
Okay, sure.
So we already said that litigation is an alternative to violence, but there are now alternatives to litigation, which has some downsides. Litigation does. The one that we primarily practice is mediation, and where that comes into play is really it's two people sitting there, or more than two people sitting down, and discussing the elements of their dispute. The mediator is a neutral that helps them reframe how they're possibly seeing the dispute. And at the end of the day, the mediator doesn't make any decisions for the parties, but the mediator will help them come to their own resolution, and hopefully it satisfies the interests of all the parties. I'm also an arbitrator, and that's a very different role than what mediation is. What arbitration does is it's acting as if I'm a private judge. Right. So I'm making a decision for the parties, whether they like my decision or not. The advantage to arbitration over litigation is that it can be done a lot more quickly. It can be done a lot more inexpensively. And you can also choose an expert in the field that you're having somebody make that decision in. If you go to court, you don't know what area of law the judge might have practiced before the judge was on the bench. It may not match the type of dispute that you have. And also, if you get jurors, they're not going to be necessarily very educated in the area that a decision needs to be made in. So the downside of arbitration is, except for some very narrow grounds, you can't appeal the decision of the arbitrator. So if you don't like the answer that you get, you're largely stuck with it.
And so that's the difference, the term binding arbitration versus non-binding, is that, no, that's...
I think it's a little bit of a misnomer in terms of...
Oh, okay.
When you think of mediation is the parties attempting to resolve their dispute and come up with their own solution. You can come to a mediation and some are resolved and some are not. If you go to an arbitration, the expectation is that whether it's a single arbitrator or some in more complicated cases you have a panel of 3 arbitrators, the expectation is that there'll be a final decision.
Okay.
So arbitration, theoretically, you do hear the term, but arbitration should be binding.
Okay.
And when you go to arbitration, in terms of, since we're getting some of the terminology out on the table, in arbitration, what you get at the end, it is a decision, generally final. Very, very rarely is it appealable, but it's referred to as an award.
I'd like to clarify one more thing. There is such a process as of non-binding arbitration, and what the non-binding means is the arbitrator will come out with an award, but the parties do not have to accept the award. So that's where the non-binding comes from.
Okay.
And the sort of the mirror image to that in the mediation world is when people hear, oh, it's mandatory mediation. What does that mean? I thought it's, within our control. And it is. The mandatory mediation, or for example, in this New Jersey state courts, it's called presumptive mediation, sometimes CDR, or complementary dispute resolution program. And what it means is the parties, the litigants, have to go, they're ordered to go to mediation and participate in good faith, but they do not, it is not binding for them to come to an agreement. It's just mandatory for them to go and participate. So that's where the mandatory and the non-binding binding come in.
So you have, within mediation, you have two basic schools of thought. One is facilitative mediation, the other is evaluative mediation. Marv mentioned earlier, he used the term facilitating because in New Jersey, in theory, we have adopted facilitative, where the mediator is a third-party neutral that attempts to get the parties to really resolve their dispute rather than evaluating their case, their dispute, and saying, well, if I was deciding, this is what I would recommend.
Right.
So.
Is the average litigant today resistant to mediation, or are they, do they think, does he or she think that they're going to get a better deal in front of a judge or a jury? Is that the feeling? What are you running into these days?
I think it's more ignorance that the public doesn't really know that mediation is an alternative to hiring a lawyer and going to court. So they just don't know that that's available in the process. As far as what kind of deal they can get, it really depends. I mean, it depends on the flow of how the conversation goes and the litigation goes and so on.
Although I've got to add to that, I think most litigants, when they file a lawsuit or when they are defending a lawsuit, at the initial stages, and I go back to my absolute thinking, they are right. I'm going to get this award. I was wronged. I want justice done. And vice versa. I did nothing wrong. I should not have to pay anything or do anything. I want justice done. By the time it gets in front of me to the mediation, first of all, they've been dragged along in the process. They realize a lot of the litigation process is out of their control. It's out of their attorney's control. It gets expensive. It gets time consuming. It's emotionally draining. So by the time they come to mediation, once they learn about it, they are so happy to have it resolved. They are a little bit softened in their resolve. That a good mediator can work with them to help them understand the other side's perspective, the other side's, do sort of a risk evaluation going forward, be a reality check. They can also, in front of the mediator, there's a mediation, we haven't mentioned this, has a big confidential component, which you do not get in a court of law, and you don't get in arbitration either. So the counsel and their client, or sometimes just the client without counsel, will come before me and we'll have joint sessions, but then we will break apart into caucuses. And I explain very carefully that what you tell me in caucus, I will not divulge to the other side unless you want me to. So what that does, it frees up the litigant to really talk freely, and it helps me as a mediator sort of identify underlying interests, identify barriers to resolution, which may not be apparent on the papers. And it gives me a lot to work with. And at the same time, they don't have to fear that they are going to weaken their case by talking because it's confidential and because I am a true neutral. I am not taking sides.
The caucus also presents an opportunity when you, taking Janine's phrasing in terms of the absolutes beginning to get more gray. The caucus is the opportunity for the mediator to perhaps be a little bit devil's advocate, begin to show that this ironclad case might look a little bit more like Swiss cheese than they had anticipated coming in. And it can be done gently. It can be done in a what-if scenario. It can be done in a way that suddenly it may give the party reason to pause, that the case isn't quite as ironclad as they thought at the time that it was filed.
And caucus also allows a mediator to really help a party assess what their risks are, because that's really what they're doing when they're trying to settle a case. Most people are risk averse, and there's a reason why less than 5%, no matter what court you look at, less than 5% of cases are decided through a trial. And that's because people don't want to take the chance of, most cases are 50-50 crapshoots, and there are empirical statistics to back that up. So most people wouldn't want to take a very large sum of money that's at stake and do the equivalent of going down to Atlantic City or going to Las Vegas, going to a roulette table, putting it on red or black and saying spin the wheel, because that in essence is what they're doing. So the caucus allows us to explore with parties, okay, so what truly are your risks here? Where are the strengths of your case? Where are the weaknesses in your case? Where might you have some problems? And the process of doing that with both sides starts to bring them closer together and ultimately hopefully get them to a number they can both agree on.
I think that's the thing that many people don't understand when they're involved in a heated litigation, or they're so firm in their rightness, and they can't imagine that when they get into the courtroom, what they thought was slam dunk, this is the best evidence in the world, suddenly it's not accepted. It's not entered into evidence, and the whole case falls apart. And that's, I think, something that people are just generally not very aware of. Why does mediation work? Why is it a good alternative?
You don't.
Go ahead. Go ahead,
You don't necessarily have to have a winner or a loser in mediation, and not in all cases. And sometimes it's just a matter of what the amount of that the parties agree to. But for instance, I think all of us at the table do employment work. In employment work, you often have lots of other options that you don't have in a courtroom, for instance, just a winner and a loser. As the mediator, especially in the caucus situation, is listening to the extraneous, that what would appear as extraneous facts in a courtroom could really be the key to a resolution in a mediation, where you may have someone who made a claim that they were discriminated against because they did not get the promotion. During the course of a mediation, they may learn that, in fact, they were missing a key skill set, or they were missing a key degree that others who succeeded had. And during the course of the mediation, when it becomes obvious that perhaps if they had that, they too would have been successful, that we have drafted resolutions where the employer says, if you're willing, I will pay. And there are all sorts of options and opportunities that you have in a mediation environment that just would never happen in court. The other thing in terms of never happening in court, and referencing what you said in terms of a bit of evidence that never got there, mediation gives you the opportunity for the participants to act, for the litigants to actually be participants. So they're not just bumps on a log sitting next to their attorney, their hired mouthpiece. Depending upon the attorney, but normally in a caucus situation, the participants really feel that they have an active role. And they, in fact, through their talking and giving you the specifics that, as Janine said, wouldn't necessarily appear on the papers, really is sometimes the key to the resolution.
You know, following up on what Terri is saying, one of the biggest benefits of mediation is that it keeps control in the hands of the participants, of the people, of the litigants, of the people involved in the dispute, and in their attorneys. And that goes more than just they're going to be, you know, have an arbitrary award or a judge's award at the end. It goes more towards when you have people who are contributing towards a resolution. There is buy-in. And so at the end of the day, they all feel it is a win-win. That's what I go for because it's acceptable to everyone. No, it's not the pie in the sky, what they had hoped for, but now they realize the risks. It's the better alternative to going forward. They can live with this result. They've been an active participant in creating that result. So at the end of the day, they'll walk out, they will live by that settlement. They are happier. And it's done in a much more informal, kinder way.
Right. And by and large, our court system really acts on money. So what you get out of most trials is either a judgment for a certain amount of money or no cause. And that may not be what the party's actually looking for. Right. They may be looking for something else, and that's what they can get in mediation.
I think that's key, and we do have to wrap up, but I want to ask all of you to stay to answer more questions because there's so much ground to cover. But I think all of these points are terrific, and I think the most important is that mediation offers a more creative solution and perhaps offers more of an opportunity to get to the heart of what's really bothering people. And sometimes it isn't all just about money, and it's about having a voice. I want to thank you so much. I'm going to ask you to come back as well. And thank you again for joining us for Pro Se Nation. This segment of our program is now adjourned.